Welcome back, dear students. In the last lecture, we had seen the scope and ramification of right to life as enshrined in Article 21 of our Constitution. In this lecture, we will see the scope of personal liberty, which is also enshrined in Article 21 of our Constitution. So, dear students, the meaning of the term personal liberty was considered by the Supreme Court in a very leading judgment, Khadak Singh versus State of UP in 1963. You see, under UP police regulations, regulation number 229B is there, which authorizes the domiciliary visits at night by the police officers as part of surveillance at the residence of known criminals. Suppose I am a alleged criminal, 4 or 5 cases are pending against me in the court of law. I am yet innocent, but the police has a right to make a visit at my residence in the midnight. I'm sleeping at home. Police comes and knocks my door just to ensure whether I'm sleeping at home or I have gone somewhere else for committing a crime. This is known as domiciliary visits at night by the police officers as part of surveillance. Supreme Court says that this domiciliary visits at night by the police officer at the residence of an accused person as a part of surveillance is unconstitutional because it affects my personal liberty. I'm sleeping with my family in the midnight and police comes and knocks at my door. What is this? This is nonsense. This affects my personal liberty. Supreme Court says that this rule of UP police regulation is unconstitutional. And the court observed that the right to personal liberty in the Indian Constitution is the right of an individual to be free from restrictions or encroachments on his person, whether they are directly imposed or indirectly brought about by calculated measures. Supreme Court held that even lawful imprisonment does not spell farewell to all fundamental rights. Even if I am in jail, this does not mean that I do not have any fundamental rights. So a prisoner retains all the rights enjoyed by freed citizens except those who are imposed on me in accordance with law. If some law says that during imprisonment such and such rights will not be available, then it's okay. Otherwise, even a prisoner is entitled to fundamental rights. Now, latest judgment, you have seen that right to privacy is also part of my personal liberty. Why police will come to my residence in the midnight? I have my privacy. And privacy is a part of personal liberty under Article 21. The latest judgment is Justice K.S. Puttaswamy versus Union of India. It was held in this case that Constitution of India guarantees to each individual a fundamental right to privacy, which is integral part of right to life and liberty. Then comes right to go abroad is also my part of personal liberty. There are two cases on this point. One is Satwant Singh Sahni versus Assistant Passport Officer, New Delhi. The Supreme Court said that right to travel abroad is part of my personal liberty within the meaning of Article 21. Yes, you cannot restrain my liberty. I may go to any part of the world for tourism or for any other purpose. It is part of my right to life. And you know the famous Maneka Gandhi's case. In this case, the passport of Maneka Gandhi was impounded without giving her any opportunity of hearing. It was deprecated by the Supreme Court. They said that such an order is violative of personal liberty. Because once you have impounded the passport of Maneka Gandhi, she cannot go abroad. And going abroad is part of my personal liberty. And you have impounded my license, my permit, my passport without giving me any opportunity of hearing. This is unconstitutional, against the concept of personal liberty as given in Article 21. Then, dear students, if I am detained illegally by the police, it again violates my personal liberty. So my right against illegal detention is part of my personal liberty. And the leading authority is Joginder Kumar versus State of UP. In this case, petitioner was detained by the police officers and his whereabouts were not told to his family members for a period of 5 days. Supreme Court held that right not to be arrested except for heinous offences and right to have informed of the arrest and right to consult with a lawyer is also part of my personal liberty under Article 21. An arrested person is being held in custody. He is entitled, if he so requests, to have a friend, relative, or other person informed as far as is practicable that he has been arrested and where he is being detained. Suppose I had gone to Goa for tourism and there I was arrested by the police. I was all alone there. Even my family members are not aware that I have been arrested in Goa. And that too, police has illegally detained me. So I have a right against illegal detention as a part of my personal liberty. I have a right that my family members should be informed immediately that I am arrested in Goa. And it is also part of my personal liberty that I should be given the right to consult my lawyer privately also. So all these rights are included in the fundamental right of my personal liberty. So it is the duty of the police officer. He shall inform the arrested person when he is brought to the police station regarding this right. And after disclosing him the grounds of arrest and that his family has been informed and that he has a right to consult lawyer of his choice, the entry of this factum will be made in the police diary. And it will be mentioned in that police diary as to who was informed regarding arrest. Suppose I am in Goa, I am arrested there. I requested the police to inform my wife. So they will have to enter into their diary, in the case diary, that my wife was informed that I have been arrested in Goa. I have been told the ground of arrest as to why I was arrested. And I have also been told that I have a right to consult lawyer of my choice. Then, dear students, another very important judgment, D K Basu versus State of West Bengal. For restoration and conserving the right to personal liberty of the citizens, Supreme Court laid down detailed guidelines to be followed by central and state investigating agencies in all cases of arrest and detention till legal provisions are made in that behalf as preventive measures, and held that any form of torture or cruel, inhuman or degrading treatment, whether during investigation, inquiry or trial, is against the concept of personal liberty falling within ambit of Article 21. And later on, because of directions given in D K Basu versus State of West Bengal, the CRPC was amended in accordance with the guidelines given in D K Basu's case. Then, dear students, as a part of my personal liberty, I have a right to free legal aid and right to appeal. If I am convicted by the trial court, I have a right to appeal. as part of my personal liberty. If I am a poor person, I cannot afford the services of a lawyer, I have a right to free legal aid as part of my personal liberty. And this was decided in M.H. Hoscott versus State of Maharashtra. Supreme Court said that right to free legal aid at the cost of the state to an accused person who cannot afford legal services for reason of poverty is a part of fair, just and reasonable procedure under Article 21. So it is a duty of the state to provide me free legal aid and tell me that I have a right to appeal also against the conviction. So right to free legal aid, right to appeal in the appellate court are part of my fundamental right of personal liberty. Then comes right to speedy trial. I am languishing in jail since so many years and trial is not completed. So much so that I have been detained in jail for a period longer than which was maximum fixed for the offense. Suppose I am detained for theft. Trial is not concluded till 3 years and I am in jail since 3 years. So the maximum penalty which you will award me after conviction is 3 years. And I have spent more than 3 years in jail. I should be released because my personal liberty is being violated. The leading authorities, Husainara Khatun versus State of Bihar. An alarming number of men, women, and children were kept in Bihar prison for years awaiting trial in the court of law. Supreme Court held that detention of under trial prisoners in jail for a period longer than what they would have been sentenced if convicted. I have highlighted this portion. That prisoners are in jail for a period longer than what they would have been sentenced if convicted was illegal and violative of Article 21. Court ordered the release from jail of all those under trial prisoners who had been in jail for a longer period than what they could have been sentenced had they been convicted. You should try me speedily, which you are not doing. State is not giving me a speedy trial. So right to speedy trial is implicit in Article 21 as part of my personal liberty. So right to speedy trial, dear students, is a part of personal liberty. In the trial, not only it should be speedy, but it should be fair also. Fair trial is also part of my personal liberty. Leading authorities, Zahira Habibullah Sheikh versus State of Gujarat. In this case, Supreme Court said that free and fair trial is sine qua non of Article 21. The first condition of personal liberty is that my trial should be free and fair. So Supreme Court held that right to free and fair trial is essential not only to the accused, but also to the victim, their families, family members, and relatives, and society at large. Because it is not only that accused wants speedy justice, victim also wants speedy justice. The family members of the victim, the society, their relatives, their friends, they also want that court should pronounce its judgment as early as possible in a free and fair manner. Then right to bail is also part of personal liberty. The reason is that accused is presumed to be innocent unless and until proved guilty. If I am under trial, I am entitled to be released on bail. Because you are detaining me, you are detaining my personal liberty unnecessarily because I am innocent till proved guilty. You release me on bail and I will attend the trial. I am ready to face the sentence if pronounced by the court on my conviction. And the leading authority is Babu Singh versus State of Uttar Pradesh. Supreme Court held that right to bail was included in personal liberty under Article 21. And its refusal would be deprivation of that liberty, which could be authorized in accordance with procedure established by law. Deprivation of liberty is possible only and only in accordance with procedure established by law. Otherwise, you should release me on bail. I'll give two sureties. I will give an undertaking that I will attend the court on each and every date. So my right to be released on bail is part of my personal liberty. Suppose I am in jail. Still you are using handcuffing on me when I am being taken to the court. Or inside the jail, bar fetters are being used on me. I'm not going to run away from the jail. Why you are using bar fetters and handcuffing? So Supreme Court in this case, Prem Shankar versus Delhi administration, struck down the rules that provided that every under trial who was accused of a non-bailable offence, punishable with more than 3 years prison term, would be routinely handcuffed. If my offence is punishable with more than 3 years imprisonment and it is a non-bailable offence, so I'll be handcuffed in a routine manner. Supreme Court says no. It is against the personal liberty of an accused person that he should be handcuffed. Handcuffing is prohibited. So Supreme Court said that handcuffing should be resorted to only when there was a clear and present danger of escape. If there is a danger that under trial will escape, breaking the police control, then you can take permission from the magistrate and use handcuffing on such accused person. But not in a routine manner on all the accused persons whose offence is punishable with more than 3 years. So right against handcuffing. Handcuffing is an additional punishment which you are giving to me. Hence Supreme Court says it is violative of Article 21. So right against handcuffing is also part of my right to personal liberty, that I should not be handcuffed unnecessarily. Then comes right against solitary confinement. I am in jail. If I am convicted, solitary confinement is one of the punishment given in IPC. Whether jailer can award me solitary confinement at his discretion? No, because it affects my personal liberty. The leading authority is Sunil Batra versus Delhi administration. In this case, the Sunil Batra was sentenced to death by Delhi Session Court and his appeal against decision was pending before the High Court. But during the pendency of appeal, the Sunil Batra was kept in solitary confinement. It was argued that Section 30 of Prisoners Act does not authorize jail authorities to send him to solitary confinement, which by itself was a substantive punishment under Section 73 and 74 of IPC. And this substantive punishment could be imposed by court of law only, and it could not be left to the whims and caprices of the prison authorities that they may keep any prisoner in a solitary confinement. So Supreme Court held that imposition of solitary confinement on Sunil Batra was violative of Article 21 because the court has not passed this sentence. Court has passed sentence of death, which is subject to confirmation by the High Court. It is not yet final. So how can you keep me in solitary confinement inside the jail? So it is my right against solitary confinement as part of my personal liberty. And if the jailer is keeping me in solitary confinement without authority of law, without order of the court concerned, then it is not in accordance with law and it is violative of Article 21. Then right against public hanging. In Bulandshahr there is a crossing known as Kale Aam Chauraha. Kale Aam Chauraha. During British period, the people were executed on this crossing publicly. It is not possible today. Kale Aam Chauraha, its name should be changed now. because I have a right against public hanging. Why I should be hanged publicly? If I am to be hanged, I should be hanged in jail privately in the early hours. Why should I be hanged publicly? Rajasthan High Court, by an order, directed the execution of death sentence of an accused by hanging at the stadium ground of Jaipur. High Court said कि hang the convicted person in the stadium of Jaipur. And it was also directed that execution should be done after giving widespread publicity through media, so that people should assemble there and see that a convicted person is being hanged. Supreme Court said that no, you can't give me public hanging. It is against my personal liberty. The leading authorities, Attorney General of India versus Lachma Devi. Supreme Court says that direction for execution of death sentence was unconstitutional and violative of Article 21. Supreme Court said that a barbaric crime should not have to be visited with a barbaric penalty. Public hanging is a barbaric penalty. It violates my personal liberty. You cannot do so. So, dear students, I have a right against public hanging. I should not be hanged publicly because it violates my personal liberty under Article 21. Then sometimes a person is awarded death penalty. His appeal up to Supreme Court is dismissed. His mercy petition is also dismissed by President of India. Now he is to be hanged, but the government is delaying the execution, delaying the hanging. So this delay affects my personal liberty. I have a right against delayed execution. If I am to be hanged, I should be hanged in accordance with law as early as possible. Why you are delaying it? Why you are killing me every day? The leading authorities, TV, Vatheswaram versus State of Tamil Nadu. In this case, Supreme Court held that delay in execution of death sentence exceeding 2 years would be sufficient ground to invoke protection under Article 21, and the death sentence would be commuted to life imprisonment. The cause of delay is immaterial. The accused himself may be the cause of delay. So Supreme Court in 1983 said that if death sentence is being delayed for more than 2 years, it should be commuted to life imprisonment. आपने 2 साल तक रोजाना मुझको मार दिया. The sword of death penalty remained hanging on my head for more than 2 years. Now I am entitled to life imprisonment. My sentence of death should be commuted to life. But the ratio decidendi of this case was overruled by the Supreme Court themselves in Sher Singh versus State of Punjab. Supreme Court said that prolonged wait for execution of a death sentence is of course unjust, unfair, and unreasonable. And the only way to undo that is through Article 21. But the court held that this cannot be taken as a rule of law and applied to each and every case. Each case has to be decided on its own merits. It's not that 2 years period has gone, the convicted person was not executed, so now his penalty should be converted into life imprisonment. Supreme Court says no. Each case has to be decided according to its own facts and its own merits. So conclusion is that if my death penalty is being delayed, execution is delayed, it is against my right to life. I am in jail. I want to write a book and get it published. Jailer refuses me. He says, no, you cannot write a book. And even if you have written something, it can't be sent for publication. Supreme Court says, no, I have a right to pen down a book inside the jail. What happened in this case? This petitioner, while under detention in jail, he wrote a book on science and sought the permission from the government to send the manuscript of the book to his wife for publication, to which the government refused. Matter went to the Supreme Court. Supreme Court held that this was an infringement of personal liberty of the convicted person, and that Article 21 included the right to write a book and get it published. Yes, this is part of my personal liberty, that even if I am in jail, even if I am a convicted person, even if I am under trial, waiting for my trial, my personal liberty demands that if I have knowledge, I can write a book, I can get it published as part of my personal liberty under Article 21. Then I told you bar fetters. The case is again Sunil Batra versus Delhi administration. Supreme Court gave right against bar fetters and held that treatment that offended human dignity and reduced a man to level of a beast. This would certainly be arbitrary and could be questioned under Article 21, but the right is not absolute. If there are chances that you are committing certain crimes inside the jail also, the bar fetters can be imposed on you. But in routine, bar fetters should not be imposed on me because it affects my personal liberty under Article 21. Then whatever you are doing, you should do on me according to procedure established by law. The leading authority I'm citing again is Maneka Gandhi's case, where the passport of Maneka Gandhi was impounded by passport authority without giving her any opportunity of hearing. Obviously, she can't go abroad, so her personal liberty is violated. So in this case, Supreme Court observed that procedure established by law for depriving a person of his life and personal liberty, that procedure must be right, just and fair, and not arbitrary, fanciful and oppressive. Otherwise, it would be no procedure at all, and the requirement of Article 21 would not be satisfied. So the procedure established by law has acquired the same significance in India as a due process of law clause in American jurisprudence. America has due process of law. We have procedure established by law, but their meaning is now same. Because if you are impounding my passport, obviously you are violating my right to go abroad, which is part of my personal liberty. Constitution has given me right to travel anywhere. And dear students, in Sunil Batra versus Delhi administration, what Justice Krishna Iyer said, he said that though our constitution has no due process clause, but after Maneka Gandhi's case, the consequence is the same. And as much as Article 21 may be treated as counterpart of the due process clause in American Constitution. Why? Because in Maneka Gandhi's case, it was said that the procedure established by law, that procedure must be fair and just. If procedure is not fair and just, again it violates my personal liberty. So dear students, this is all about the scope of personal liberty. Thank you very much. God bless you.